I'd like to welcome you to the September meeting of the St. Tammany Parish Board of Adjustment. If everybody would please silence every electronic device you have. I'm the worst culprit of this, so I'm going to turn mine off now. Any appeals to the decisions of this board should be addressed to the 22nd Judicial Court. Speaker cards are available, and they have been coming in regularly, but if anybody else wishes to speak, I think the speaker cards are right over here, and you can turn them in to a staff member. For public speaking today, 10 minutes will be allowed for the person making the request, and 10 minutes will be allowed for the opposing opinion. And after that, each side will have an additional 5 minutes for the request and those against it. And then after the case has been heard, we'd ask that everybody please quietly leave by the back there rapidly so we can get on with the next case at hand. It is 2 o'clock. And I would like to point out to everybody, an affirmative vote requires 4 votes of the board. So in order for something to pass, we have to have 4 votes. And today, we only have 4 people here. So it would have to be a unanimous decision. So if there's anybody here that has a case that would not like to roll the dice with us all being the voting the same way, you can withdraw your case and postpone it to our next meeting when we may have 5 members. But as of right now, we only have 4. Is anybody interested in withdrawing your case for today and putting it off to our meeting in October? Seeing none, we will. Okay. Madam Secretary, can we have a roll call, please?
Mr. Valentine from Mandeville.
Here.
Mr. Daly from Covington. Mr. Blosh from Mandeville.
Here.
Mr. Swindell from Covington.
Here.
Mr. Sanders from Slidell. Mrs. Thomas from Mandeville.
Here.
Mr. Chairman, we have a quorum.
Mr. Swindell sitting as a
I'd like to recognize Mr. Swindell to your right, my left, as a voting member today. So his vote will be scored. Okay. How about a review of the minutes? Anybody have any comments on the minutes from our August meeting? Seeing none, can I have a motion to approve the minutes?
I move that the minutes be approved.
I have a motion from Ms. Thomas to approve the minutes,
Second.
and a second from Mr. Blosh. Please vote with your screen.
Motion carries.
Okay. Where are my glasses? I need my glasses. Our first case today is BOA case number 3430 BOA. It's a request by an applicant in an HC2 Highway Commercial Zoning District to appeal the decision of a parish council, a parish official, regarding the issuance of a land clearing permit and building permits. The property is located at 72147 Military Road, Covington, Louisiana, Ward 3, District 2. The applicant and representative is Mr. Robert Barnett. Staff comments, please.
The St. Tammany Parish Planning and Development Department staff has been advised by our legal counsel, the Civil Division of the District Attorney's Office, that the Board of Adjustments does not have jurisdiction to determine Mr. Barnett's claim. Pursuant to the BOA Bylaws, Article 2, Section 1, the Board hears appeals and applications for variation or modification from the UDC and/or the floodplain ordinance. Section 5 provides that no application for a variation or modification of the provisions of the UDC and/or the floodplain ordinance shall be accepted by the Secretary or heard by the board except in a specific case and from an order, decision, or determination made by the Director of the Department of Development relative to the UDC or by the floodplain administrator relative to the floodplain ordinance. Therefore, the BOA does not have jurisdiction to determine the legality or enforceability of parish ordinances unless the issue specifically pertains to the UDC or the floodplain ordinance. We have been advised by the DA that Mr. Barnett may appeal this determination, which is lack of jurisdiction, to the 22nd Judicial Court for the St. Tammany Parish. Regarding appeal issue number 2, permits issued to non-owner, the complaint regarding whether the permits were issued to someone other than the owner, please see the attached Ms. Karen Jones affidavit. Regarding appeal issue number 3, which is code enforcement complaint concerning Mr. Barnett's appeal related to code enforcement, Mr. Barnett did not attach his complaint, and therefore staff nor the BOA has had sufficient information to consider his appeal. Should we receive additional information, staff will supplement its report to the BOA.
Thank you. Mr. Barnett, please state your name, address, and your relationship to this case.
Robert Barnett, P.O. Box 4269 in Covington. Ready to proceed?
Proceed.
All right, I've handed to everybody a set of documents that I'm going to introduce into the record at some point during my talk today. They're not stapled, and I apologize to everybody, so please be careful when you pull them out, but there is indeed a cover page that will highlight you to each exhibit. First, what brings us here today are 2 separate matters that are pending. One is the appeal, which we'll get into in a moment, about a complaint that was made to the Code Enforcement Division that dealt with the allegation of fill and clearing on this particular piece of property without permits. And we'll get into the photographs later. That's issue 1. Issue 2 is 3 permits that were issued, shall we say, improperly, untimely, prematurely, and I hate to use the word surreptitiously, but we'll get into the facts here as to what happened on this project that's been known to the administration for over 2 years. First, you have basically 2 options today, Mr. Ballantyne, as a group, to thumbs up that the permits were not properly done, or down, that they need to be rescinded. And we're going to talk about those in just a sec. First, to lay the precedent, what we have here, BCP North Shore Properties owns this property as of this week. I've personally run the records. They own it. It has not been transferred to anybody else. I've also done a public records request and have some 15,000 pages of documents, and I find no proof nor agency between BCP Properties North Shore and the prospective owners. And that's important because what you're going to see is in a lot of the paperwork, we have permits being issued to someone who doesn't own it. The permit, the first one I want to talk about is permit that you see here, go down to number 14. That is a permit that was issued on May 24th of this year to Military Road Revitalization. Well, Military Road Revitalization, I think they mean HRI, Military Road. I don't want to get lost in the nomenclature, but you can see here it's been issued to somebody, if you look through your packet, it's been issued to somebody who doesn't even own it, who has no agency. Then, on June 1st, you have a land clearing permit, where there's, again, it's been issued on June 1st, and that's number 15, to North Shore Properties. Then you have one for a bicycle shed issued on June 5th. Now, meanwhile, this is important. You need to get the timeline straight here. You've got a series of moratoria that have gone into effect, and we can have a legal discussion as whether or not when they take effect. But we have one May 4th and then June 1st. We also have a resolution, and this is key here, a resolution that was passed unanimously by the council that there was an investigation enacted to look into what happened in this case by the parish council. Now, I'll represent you, and I'm going to go through these quickly because I don't have a lot of time. The President Cooper started off in Exhibit 20 saying that he instructed in writing council members were not allowed to talk to the staff. Well, that's in direct violation of the charter, but that's of no moment at this particular point. There's going to be a series in number 22 where there is a no net fill ordinance that was written many years ago, but we've got fill that's being brought in here, and the photographs are going to speak for themselves. I have also put in here Exhibit 24, photographs of the pile driving that was going on here without any permits and that were removed after we appeared here on June 1st. Within the next week, they removed the piles that they had put in. They were sitting there ready to go. So we have activity on the property by somebody who doesn't even own it. The traffic backup, apologize. Number 25, I have photographs, and I'll get a video later, that reflects that this property flooded in 2016. It jumped the banks there, and it not only went on the other side, on the Boston Street side, but on this side, we have about 2 feet of water on property that theoretically doesn't flood. The traffic backup, the number of pictures have been taken to show what the backup is now, even before school started. Traffic is horrendous, and people here may talk about it today, Mr. Valentine, I'm not sure. And let's talk about traffic for a second. There's an internal memo that we came across that I'd like to point out. It's it's Exhibit 35 and also 33. It appears more than once. The state said there's no traffic impact here. And the problem we've got, Ms. Thomas and gentlemen, is that they're saying right turn only. And what that means, if you're familiar with this intersection, people have to come out of downtown Covington and to get into the existing daycare that has, 100 kids there now? And now you're adding 200 more cars. There's no left turn. They've got to go right only, so they've got to go all the way up to Melissa Lane, if you look at the map, and come around and then try and take a left off of Highway 36 and then get to a Military Road to take another left to come back. This is going to be a real problem. All right, that's an internal memo, but the parish of it said we don't need a traffic impact study. All right, there's not a lot of time here. There are a number of complaints that have been lodged, and photographs are in this packet that reflect that the clearing's been done, and it's all been done in the back, and the trees have been pushed into the ravine down by the river. That's going to cause a real problem downstream, but the point is, there's been clearing done. No permit was done. No permit was had. So that is a real problem. All right, winding up here, the Department of Wildlife and Fisheries will not take a complaint until we demonstrate that there is in fact an impact. And the only way to prove an impact in discussions with Wildlife and Fisheries is that after the project is developed. That's a real problem. But that's the way they play their rules in Baton Rouge. And speaking of Baton Rouge, I want to talk about the funding for just 1 second. The funding here was through the Office of Community Development. And as I know, Peter McHenry may speak with you in a moment, but I had a conversation with the head of OCD, Office of Community Development, Mr. Forbes, and I said, we have a moratorium, we have all these issues, traffic, flooding, etc. He goes, the Office of Community Development said, we don't get involved in local community issues. But that's a whole nother issue for state government in Baton Rouge. And I think Peter McHenry can vouch for that because he had the same conversation. I want to get to, since time is short here, some important emails, and I'll just represent to you, these are in your packet. The parish president issued, and that is going to be exhibit, bear with me for a second, exhibit 28 was a comment period established by the parish that said by President Cooper, there shall be no permits issued until June 8. That's an internal memo that I got my hands on, June 8. But nevertheless, some were issued. ahead of time. And that's kind of what brings us here today. We have 3 permits that are issued, and they all say building permits. So if you look forward to the end of the packet, there is some exchanges about the lack of notice and the need to notice. Permits are issued, Ms. Thomas and gentlemen. They're issued, as I said, in May and in June. There are exchanges here in Exhibit 38 where it is said that the parish cannot issue these notices to the public, which is what probably most of these people here today are. They cannot do it timely. You must do it. HRI, not BCP, HRI. And HRI says, we'll do it. But what we have our hands on is a declaration from the legal department at the U.S. Post Office, Exhibit 39, that says there was no posting at the post office with permission. So they violated their own agreement, not just the June 8th deadline, but notifying these people that are sitting behind us there was nothing posted. And then I point out to you 2 posts by Mr. Cooper, Exhibit 41, a June 8th post saying no permits have been issued. That's not true. And then a letter to the editor in the paper, Exhibit 43. No permits have been issued. So something's just not making sense. And just one final comment. I'd like to file and introduce all these exhibits 1 through 43 into the record. Mr. Ballantyne, I have to make a record in the event that there is an appeal. And one final comment that's of note, that you need to know the problems with traffic. There are a lot of people that don't know this, but there was an incident in Rouse's parking lot where somebody was having a medical incident, and the fire department and ambulance could not get out of downtown Covington in time, and somebody died.
Thank you, Mr. Barnett. Your time has expired.
Yep.
We have more speaker cards.
If we ran out of speaker cards over here, so there are more speaker cards over here to my right on that podium if you'd like to fill out one, but we'll now go to comments from the opposition. Should we take this in some kind of order? Or
The building permit applicant's attorney is here, I believe, Jeff Shane.
I'll start with, I'll recognize Mr. Jeff Shane. Please approach, state your name, address, and your affiliation.
Good afternoon. Jeff Shane of the Jones Fussell Law Firm, Appeal Box 1810 in Covington. I represent Military Revitalization, who's the developer of the project. Before I start on the clock, Mr. Chair, I understand it's 10, 10, 5, and 5.
Yes.
Wanted to make sure that I understood.
And I want to make it clear, the opposition is a total of 10 minutes for anybody in opposition. Whenever you're ready.
May I proceed? Thank you,
Yes,
sir. Again, I represent the developer of this proposed project known as the Military Trace Ridge Apartments. Again, as I appreciated the staff report that was read to you, I believe it's the recommendation of your counsel, the District Attorney's Office, that you do not have jurisdiction to hear at least the first matter as it relates to the permits. I'll certainly allow you to make that determination and deliberation later. But I think that whether you decide that you hear the matter or have jurisdiction or not, there's certain points that I wish to make. I have given you those points as outlined on the memo. To give you an idea, the memo is only 2 pages, the first 2 that you see, and then I have referred to documents in the memo that are attached in case you need to make reference to it. With all due respect to Mr. Barnett, I totally disagree with his positions given to you this evening. It's been my experience in handling matters like this for a good many years now, that when people throw a lot of things at you trying to hit the wall, it tells you that they may not have something that really should stick. And I think that's what we just heard from Mr. Barnett. As I appreciate his complaint to the board, the primary issue was with regard to the effectiveness and retroactivity of the moratorium ordinance as it related to the 3 permits that were issued. And in fact, if you look at the exhibits that I assume were attached to Mr. Barnett's documents, I was not privy to that, a copy of that packet. I'm not complaining, I'm just saying I wasn't privy to it. I think you'll actually see it's very clearly a clearing permit, a demolition permit, and then a document that is styled a building permit for the retrofit of one of the buildings. So the other things that are very interesting to me is that his petition to your board suggests that the moratorium ordinance was retroactively effective and that it became effective on June 1. Again, I'm going to stick to the issue that was raised in his complaint to you. The moratorium ordinance was passed by the council on June 1. The moratorium ordinance was signed by President Cooper on June 8. If you look at the permits that were issued, they were issued May 24 before the council took action, June 1 before the council took action, and granted the 3rd permit was issued on June 5. Now that's after the council adoption, 3 days before President Cooper signed. You will also see in the memorandum I've given you the specific law that we think is effective in this case. And that is that unless the ordinance specifically specifies a date to which it has become effective, it's presumed to become effective at the expiration of 15 days after adoption. Take a look at my memo, page 1 toward the bottom, that actually gives you the provision of the Home Rule Charter. And this is the point of emphasis. The charter, the governing law of St. Tammany Parish, says that until the ordinance receives final approval, that's the word it uses, final, and it tells us that final approval occurs when the chief executive officer, the parish president, signs the ordinance. He signed the ordinance on June 8. The ordinance does not say it becomes retroactively effective. The ordinance does not say it becomes effective June 3 or June 4 or June, it just doesn't have a date. So my point to you is that if the moratorium ordinance was validly adopted and became final after signature by President Cooper, that all 3 permits that have been issued in this case were issued again May 24, June 1, and June 5, all prior to the final adoption of the moratorium ordinance, none of which were issued at some point that became ineffective due to some retroactive application. I think that's very important. The other things I would like to bring to your attention is that there are provisions in the moratorium itself that says it shall not be applicable, and this is the 2nd page of the 2-page memo in front of you, shall not affect the development of property for which the issuance of permits has already been approved by the Parish Department of Planning and Development or the Department of Permits. We've just talked about those 3 permits that were issued. It also, the moratorium ordinance, does not affect the development of property that has already received multifamily zoning approval. Now, although this property is zoned Highway Commercial 2, it's our belief, and in fact that's supported by a memorandum and opinion from the Director of the Department of Development of the parish, that multifamily is in fact a permitted and legal use within the zoning classification. So what is my point? The moratorium ordinance, final adoption, all 3 permits had already been issued. And if so, under the very terms of the moratorium ordinance, it's not to be applicable to any project where permits have been issued. And there are 3 permits that were issued in this case. Now, a few other comments in response to some of Mr. Barnett's suggestion. My client agrees that such things as traffic and drainage and clearing, etc., are extremely important, not only as to this project, but to any development. But the parish has laws on the book that regulate what developers need to do if they're going to build a project. I may have misunderstood Mr. Barnett, but contrary to what I heard, there is in fact a traffic impact analysis. Numerous versions have been submitted to the parish planning department, or I should say the engineering department. The latest version is still under review by the engineering department. A drainage study has been in for months. My point is that we understand that no development can nor should go forward without meeting all the requirements of law, which again, often traffic and drainage are perhaps some of the more important. So I wanted you to know that those items are not being disregarded. Studies pursuant to parish regulations have been submitted. Those studies are under review, they're under continuing comment, but the developer understands what it needs to do in order to proceed. I would also suggest, I am not familiar with Mr. Barnett's suggestions about a lack of notice or a lack of posting. That's just ignorance on my part. I'm not sure that I fully understand that issue. I only know that everything that's been asked of my client as a developer, we have tried to perform or do to the best of our ability. We were not given any specific letters, emails, etc., to my knowledge, suggesting that we had not done something that we were supposed to do. The idea was certainly to try to develop this project in accordance with parish law. In my closing moments, I would like to say that although I understand this project has caused great concern and consternation from many residents, some of which are here today, some of which are not, I think you as a board, I hope that you understand that when this site was selected, I and others on our development team investigated whether or not the current zoning allowed for the development of an apartment project at this location. We came to the conclusion that it did allow it, meaning it was a permitted use. We then started working with parish government in order to learn of the things that we would need to submit in order to get the necessary permits in order to build this project. That's really not rocket science in the sense that, gee, Jeff, we understand. You want to build a house, you've got to get a building permit. You want to build an apartment complex, there are a lot of permits that you have to get. My point is that my client's a responsible corporate citizen, a very successful developer of projects over many, many states. In St. Tammany Parish, we intend to stay the course in terms of doing the things that are required of us by law, doing them properly, to make sure that if we are entitled to a permit, we build a project that in fact works. I thank you for your time.
Thank you. Okay, now is it appropriate to go for rebuttal? So I'll have 5 minutes allowed for the petitioner to comment if you would like to do so.
Thank you, Ms. Valentine. We're not here necessarily to fight whether or not this is HC2 or not HC2. That's for different people that perhaps wear black robes. I can't help you there. I just disagree with their finding that this is HC2. We're also not here, and we're missing the boat, and I've got to bring you back in. This is not about the effective date of the moratorium. The moratorium that was in effect, that was voted upon on June 1st, is effective on the date June 1st. And again, that perhaps is just something for someone else in a black robe to decide down the line. What I think this board can do is, if you look to see, and I don't want to just focus on this, is that you have a deadline. And whether or not there was notice issued or not, the records are very clear between the parish and HRI. We cannot post this timely. And HRI says, we'll do it. And they didn't. But that's what the post office records reflect. And trust me, getting something from the post office these days by mail is difficult. But it was done. So, but you got to look at June 8. Permits were issued before June 8, before the comment period was up. Hence, all the permits that were done were premature. So this board should, if it does the right thing, take that into consideration and say, folks, you got to start all over again. The comment period wasn't up by your own black and white admission. That's what we're here for today. And this issue about flooding and fill, I urge you just to take perhaps a look at the pictures. And what's troublesome, one thing I did mention, the appeal about code enforcement. An appeal was filed right after the council meeting, or right during the council meeting, June 1st or May 30th. The resolution that was passed by this council that was sitting up here said, we're investigating the parish president. But what happened is that my appeal to code enforcement for violation, pictures with fill being brought in, trucks, pilings, the traffic issues, the land clearing, anything that could have, should have been done ahead of time, that was brought over to the parish and filled out on their forms. And I did a public records request. They're not even producing that which has been filed. The only thing that I have is an email from them, and that's Exhibit 19, that says we haven't invested. We're not going to do anything. And I contacted code enforcement. I said, why aren't you investigating the complaints about the violations of the code? And they said, because we're under investigation, we're not going to be doing anything while the investigation is live. So I've appealed that, Mr. Ballantyne. There should be action taken by the parish to investigate claims that have been made. They're not even investigating that. That's the first one. And two is the fact June 8th deadline never even hit before the permits were issued. That's what we're here on. You have the ability to vote the permits out and make them start over and do it correctly with the correct entity.
Is there anyone else here that would like to? Anyone else here that would like to speak in opposition, or no, in support of the request? Seeing none.
This gentleman's after his sandwich.
Yes, ma'am.
Come up to the podium, please, ma'am.
Please state your name and address, please.
The name is Eloise Kistja, and my residence is 21228 Wilson Road, Covington. What else do you need?
What you raised your hand? What did
Well,
I was
my
asking?
question is I don't want to be overlooked, and what I'm here for is to talk about not building this tremendous project and the permits for you to rescind them. Now, am I right now, or should I wait later?
No, you've made your point, and it's well received. Thank you.
Okay, well, do I have more time?
42 seconds.
Beg pardon?
You have
42 seconds.
You all are impossible to deal with. I mean, you know, I'm not being arbitrary, but I mean, I have something to say, and I think it's important. And I would like you to give me a few minutes, not long. I don't need 10 minutes, Just a few minutes.
What would you like to say?
Well, first of
Very
all,
quickly.
I own the property across the street, and currently I have a tenant. That tenant is not going to stay if you all conjust the traffic the way it is. You're currently talking about a traffic circle, which is fine. You have improved it. The traffic in that section is impossible. You cannot do it. You need to rescind the building permit and let them start all over again.
Okay, thank you, ma'am. Okay, now we have 5 minutes additional for people in opposition. Shane, would you like to?
Can I speak, sir? I keep standing and raising my hand. I feel
The time limit has run for the side that has made the appeal. We're now in the rebuttal period for those that are
We're doing
challenging the appeal.
5 minutes for rebuttal
I got an idea.
in opposite or in support of the project.
So
Yes, sir.
Yes, sir. We're going to divvy up our 5 minutes. Ms. Stevens going to take the first 2, and I'll take the last 3.
Okay, thank you. State your name and address.
Terry Lewis Stevens, 725 Dove Park Road, Covington. I have a copy of the same PRR that Mr. Barnett got. And yes, there were 14,000 documents in it. A lot of them were duplicates. I am an experienced public records requester and reviewer. And I will say that I attended the meeting last week that was held, I don't know why it was held, but it was held in downtown Covington, where, let me just start by saying this. Truth is important, facts are important. And there were some non-facts that were conveyed then, and there were some non-facts conveyed today. First of which, let me just let you know that one of the public records showed that Mr. Fitzgerald, who's the councilman for the area, who claimed that he didn't know about this project, had been invited in April of 2023 to a meeting. Whether he attended, I don't know, but he was notified, and there was a meeting. Let me also let you know that there's an affidavit that's included in the PRRs where it shows very clearly, and this is Mr. Barnett's PRR, that BCP North Shore Properties were the ones that got the land clearing permit and the demo permit, which they could do without any building permit. The building permit was for a 324 square foot. 300, that's like a room, a small room, bike shed. That's what the building permit was for that particular project. So it didn't give full permission for anybody to do what the entire project. But let me go back to what the truth of the matter is. This particular piece of property back in 2009 was zoned, or 2009, the parish council allowed apartments to be in HC2. This particular developer looked for a piece of property where apartments were allowed. And I happened to look it up before I came here. If this same project was in an A8 zoning category, they would have been able to put 150% of the amount of apartments on it, so it wouldn't even be better. This is actually a down zoning from what it would be if this had been a residentially zoned property, but it's commercial. HC2 allows apartments. That's the part that's really important. And the parish council did not put a moratorium on HC2 in the meeting minutes from the June meeting. They did start an investigation, but I looked through all the documents as well, and I look at them very closely. There was no sleight of hand. There was no nonsense. This was completely above board and very, very professionally handled. So no, there's no dog in this hunt for an appeal on this matter. Thank you.
Thank you. Mr. Shane.
Thank you. With regard to Mr. Barnett's comments, particularly with regard to the issuance of the permit and whether or not it was issued to the right entity, I know that you will, but please take a look at the affidavit of Ms. Karen Jones that's attached to your staff report. Ms. Jones is the commercial facilitator, permits and inspections for St. Tammany Parish. And in pertinent part, and I'm reading item 5, it says completed permit application requests are issued to registered contractor per parish ordinances. So my point is that the person that issued the permit that has the specialty, the expertise, the experience in parish government, has confirmed by affidavit that it in fact was issued to the appropriate party, the contractor. The owner is important as it relates to who owns the property, but typically permits are not issued to owners. Owners don't have licenses to build and construct and develop. People that develop land and construct structures, et cetera, they're regulated by laws and have to be licensed. So that's the point that I'm making there. The other point I'd like to make, which I think is very important, I'd like you to take a look at the ordinance, the moratorium ordinance that's attached to the memorandum that I gave you. And I'd like you to go to the second page. That's a legal-sized document. It should be easy to find in your packet. Because I want to read to you, and this is really, I think, the spirit of the argument and why I so much disagree with Mr. Barnett. The moratorium ordinance specifically says, it has a section, effective date. This ordinance shall become effective immediately. And Mr. Barnett tends to stop there. But what are the three words after that? Upon final adoption. I now want you to look at the section that I cited to you on the first page of my memorandum out of the Home Rule Charter for St. Tammany Parish. In subsection C at the bottom of the first page, it clearly says, with the final approval of ordinances by the president. That ties us back to that June 8 date. My point to you is parish law clearly states that final adoption occurs when the parish president signed on June 8. Hence, all three of these permits were issued properly. Thank you for your time.
The 5 minutes for the rebuttal of those in opposition has expired also. So how do we address?
Make this part of the record.
What?
We've received more speaker cards than we have a lot of time to hear all of those speakers. So anyone who has submitted a speaker card and who has not had a chance to speak because at the expiration of time, those speaker cards will become part of the record of the hearing.
Can you at least give us 2 minutes for everyone to say something? I mean, we had no chance to say anything. I agree.
That's under the rules of the BOA. It says each side shall have 10 minutes per side and shall have 5 minutes of rebuttal. It does not have a mechanism for the board to extend that time period.
I hear you, but I feel like this is an extenuating circumstance, and you should at least give us 2 minutes each to talk. What's the difference? Well, I mean, you don't need to get heated here. I just want to say.
This is a quasi-judicial board. It operates more like a court than it does like a parish council where each person.
You all are responsible for serving the public. You are appointed to this position, and you do not have the right to tell the public, oh, we ran out of time, you can't talk.
Those are the rules of the Board of Adjustment under the bylaws adopted by the parish council.
Well, in this instance, you all are violating or certainly preventing the public from expressing their opinion. And that is egregious.
Take 2 minutes, I'll take 2 minutes. I just want to make a note about
Wait, no, wait a minute. No, Mr. Barnett, your time has expired also.
Yes, as an officer of the court, I need to let the board know that I think Ms. Couvion needs to remove herself. She's been recused from this matter. Just a point for the record.
If I got in my hand here the request to speak, and if we, as this gentleman expressed, 2 minutes, we would be here till late in the evening to get two minutes into those. So what's that? I would like to. What's that?
Excuse me for a moment. For the
We
record, I
can't.
submitted handouts to Mr. Blaze, and Mr. Blaze said he would pass those handouts to each of you. So I want that in the record. Is that correct? My name is Peter McHenry. I live at 74519 Old Ferry Road, affiliated with the McHenry Company.
And we'll make sure those are in the record. No. No, not right now. Can we, I'm looking for guidance.
Doesn't the board have discretion to expand the time?
No. The time has expired and we're,
We're wasting more time by not doing anything. So I could have been done by now.
but then if I allow you to speak, I'm gonna have to allow, everybody to do 2 minutes.
It's not, I mean, it's not life or death, it's 10 more minutes.
Yes.
Chairman, at this point in time, I mean, I have no issue with listening to the public and the input. That's not a problem. That's not my point, though. My point is I still have some questions with regards to our council and in terms of whether or not we do, in fact, have jurisdiction to make a decision here today. Because if we don't, then we're wasting everyone's time, okay?
Mr. Chairman, I agree with that. I need to understand what our board is allowed to do or not do in this situation. We all, regardless of not what you think, we are really not the demon, but we do have to apply, we have to follow our rules and parish council rules.
Sure, but as a citizen, this is the only.
I understand, I'm a citizen too, sir.
You don't understand your own rules, so let's take a vote, let's keep.
We need
Okay.
to understand what our jurisdiction here is, whether we can vote or not.
That's
That's what we need to understand.
we're trying to get now is guidance from council. Go ahead.
James Bolner for the District Attorney's Office. This board is a board of very limited jurisdiction. It's a quasi-judicial board. It does not make legal interpretations in the sense that a judge does. There is a pending litigation right now where all of these issues are presented. And this question about when the individuals in the audience will have an opportunity to speak is not something that is relevant to the issue of whether or not there's jurisdiction for you to decide this issue. There are two types of issues that you all decide: floodplain issues and UDC issues. That's it. So you're not tasked to decide issues that are specifically relegated to the judiciary. Neither one of those were addressed by Mr. Barnett or by Mr. Shane. So the provisions of the parish ordinances, the charter, of the rules applicable to the Board of Adjustments are very, very clear. And that's the limit of your jurisdiction. The other issue you can address, which is whether or not the permits were properly issued to BCP North Shore Properties LLC, as evidenced by Karen Jones' affidavit. I think that issue is pretty final. And then the last issue, which is whether or not Mr. Barnett's complaint about the code enforcement was properly brought before the board. My understanding is the information that he relied on when he spoke from the podium was included in the information that was handed to you at the podium just before we began, which was not submitted to staff. So I would submit to you that that issue is not right for determination, and you could come back and address that at a later date, or you could rule on it now. But the first issue is not an issue, in the opinion of the district attorney, that you have jurisdiction over.
Again, I'm going to guide you right to it, Mr. Valentine. We'll just cut to the chase. First, again, I don't know this.
Mr. Barnett,
but he
you've
shouldn't
had
be
your-
participating as an assistant DA. He's recused. He cannot participate.
I can address that,
That's a
Mr.
whole
Barnett.
other
Mr.
issue.
Barnett.
Wait a minute, Mr. Barnett.
I'm going to cite you to the law.
I can address that.
Let's talk about the law.
I can address that.
Mr. Barnett, please step back. You've had your opportunity.
130.32. Look at it, it's page 2 of your documents. It says specifically, Mr. Valentine, appeals to the Board of Adjustment may be taken by any person aggrieved by a decision
Mr.
of
Barnett,
the Department of Planning.
Please step
Zoning.
back, sir.
It's right there in your own black and white.
Would you like to address that?
I can. Your Honor, Mr. Barnett is incorrect about the issue of disqualification. It does not pertain to me. That was an issue that was addressed by Judge Burris in the litigation, and it's inappropriate for him to bring it up as a spectator from the audience in the way that he did. The issue that you raised about jurisdiction, you have to look at more than just one sentence taken out of context. It's a complicated issue, and we've formed our opinion. We've given it, transmitted it to you through staff, and I think that it stands for what it is.
Thank you. All right, how would the board like to proceed? We can, there are actually two issues that we could provide guidance on, and probably one of those we should leave for a later date. Is that okay?
Yes.
How would the board like to proceed?
Let me ask a question about the two. One of the issues that you'd mentioned that we could actually look at, in your opinion, at this point in time, is whether or not the building permits were issued properly in a timely manner. Is that correct?
Whether or not they were issued to the proper entity.
Okay.
The timeliness is a whole different question.
Okay.
So that's BCP was issued the permits.
There's no dispute that BCP North Shore is the current owner of the property, and that any permits, according to the permitting department, are identified with that owner. And they're also identified with a specific contractor. As Mr. Shane said, permits are issued to contractors. Military Road Revitalization Company, LLC, has not been issued any permits in connection with this property. None. There are 6 permits. 3 were issued. None of those permits were for new construction of multifamily housing. None of the 3 permits that were issued.
Okay.
The 3 permits that are unissued are subject to the moratorium and will not be issued absent a court finding that the moratorium is unconstitutional.
Okay.
I have issues with comments being made by council because Exhibit 14 specifically says permits are issued, building permit. Look at Exhibit 14.
Mr. Barnett?
It's issued to Military Road Revitalization.
Mr.
Company.
Barnett, you've had your time.
That is incorrect. He's representing something that's not accurate.
Okay. What's the other issue? Yeah.
We just overlooked it. We have to note it's on that.
We need to get order.
The chair will recognize Mr. Swindell.
Go to Mr. Blash, he's got a comment.
No, I didn't. I'm good.
good.
I just, I'm a little bit distracted, Mr. Chairman. If we could have some order, I really would appreciate it. Okay.
What was that?
We could have order in the courtroom, please.
Okay.
Sure. How do we make formal note that we should not take any action on appeal issue number 1?
So
Or that's outside of our
Purview.
in the reading of the appeal of those 3 permits that were issued, and again, the 3 permits that were issued were for land clearing, for demolition, and for remodeling of the bike shed. And there were 3 bases for the appeal of the decision to grant those permits by the Department of Planning and Development. One issue, which is described as issue number 1 in your staff packet, was that the moratorium was applicable and they should not have been issued because there was a moratorium in place for multifamily properties. The second issue is that the permits were issued to reference is also made to real estate records in this parish that permits have been issued to applicants who do not own the real estate at Covington Trace Ridge Apartments. So that's issue number 2 identified in your staff packet. And then issue number 3 was, I'm going to read it as it's written in the appeal of permitting. I incorporate in full a pending complaint lodged with parish code enforcement under my signature. Upon information and belief, parish officials will not investigate any complaints concerning Covington Trace Ridge Apartments because of a pending investigation of the office of the parish president. So those are the 3 issues that are before the Board of Adjustment today for those 3 permits.
So how does the board formally note, or or do I need to make a motion that we not take any action on legal on issue 1 based on the district attorney's opinion?
Can we take these individually, 1, 2, and 3?
Yeah.
Is what my question
Yeah.
is.
Yes, you can.
Okay.
Okay, let's address.
All right, so I'll make a motion that we not take any action on appeal issue number 1 based on the district attorney's opinion.
So we have a motion by Mr. Swindell that we would not take any action on the appeal number 1, and a second by Ms. Thomas. Any other discussion on that?
And just for clarity of the record, is that on the grounds of lack of jurisdiction by this board?
Yes.
Okay.
Yes. Okay, seeing, please vote with your screen.
Is there discussion, please? There's usually discussion before a vote, Mr. Valentine.
I asked for further
I raised
discussion.
my hand, but I was not
No, the discussion is for the board.
Yeah.
No.
I filled out the card, my name is there, I asked to talk for 2 minutes.
And your card will be made a part of the record.
Oh, that's cool. Can I say something?
No.
Again, this
The
is
time has expired. Right.
Because we wasted a lot of time. With all due respect, Mr. Valentine, there's been a motion and a second. We're entitled to public comment.
No,
before a vote.
no, you're not in front of the BOA.
You need to back down out of this.
No, no, that's incorrect, Mr. Barnett.
Mr. Barnett, please step back. Please step back.
And if, I will read the bylaws, this is from Article 1, Board Meetings, from Board of Adjustments. It says, when hearing a case, the board shall adhere to the following format. The case shall be read into the record by the board chairman. The staff shall read the staff report into the record. The applicant presents his or her side of the case, 10 minutes maximum time. Opponents, if any, present their side of the case, 10 minutes maximum time. The applicant offers his or her rebuttal, followed by the rebuttal of opponents, if any, 5 minutes maximum time. The floor is closed and the board deliberates the case, and then action is taken by the board. That's from Article 1, Board Meetings of the St. Tammany Parish Board of Adjustments bylaws.
Thank you. All right, now let's go to the next, did we vote?
We have not voted yet
Oh.
on that first motion.
Please vote with your screen. Everybody voted?
We did.
All in favor? Motion pass.
Motion passed. Okay. Now we go to the next item. You want to try that?
Pretty easy, this one.
Sure, yeah. I'd like to make a motion with regards to issue 2, and I'm going to stay in the spirit of making an affirmative motion, right? That we approve appeal issue 2, that permits were issued to someone other than the owner. I want to make it clear that I will be voting nay to this based on the information that we have in front of us, in particular the affidavit.
I've had a motion by Mr. Swindell to approve. Do I hear a second?
Second.
And I have a second by Mr. Blash. Any other discussion, further discussion by the board?
I would.
Seeing none, it's only the board.
Objection for the record.
Not on the board, so.
Sit down, sir. I'm not addressing you. For the record.
Mr. Barnett, please sit down.
A note of the record, and I'm objecting. I don't even know who you are. I'm making just a note for the record, Mr. Valentine, that's it.
Okay, everybody vote with your screen. Has everybody voted? We made a motion in the affirmative, and we would vote against that.
Motion failed? The
The
motion failed.
Okay, we need one more.
Yes, issue number 3.
We
Yeah.
need,
Regarding issue 3, I guess it's best to make a motion that we don't rule on this based on a lack of information on our part. I mean, is that,
Information and
I mean, we haven't been presented with information to make a decision one way or the other regarding issue number 3. So do we have to make a motion to push that to another meeting?
The board does have the authority to request additional information from the applicant. You can request that information be provided and postpone that prong of this appeal to a later date, if that's the wish of the board.
do we still have the jurisdictional issue? If we don't have jurisdiction,
Yeah,
how
I
do we
mean,
get
that's a
more
code.
information?
I don't know if we can really, if the jurisdiction's been considered because there has not been information provided.
Yeah, you still have jurisdiction to decide that issue, and Ross wanted to make a comment.
Yeah, just so everyone's clear, we do have an open investigation of code enforcement. Every time a complaint comes in, we open an investigation. That investigation is currently ongoing. So at this time, we don't have any final reports made, but there is an open investigation. So we take all in, what word am I looking for? All complaints seriously.
Any idea of a time frame on that?
Before your next meeting, for sure. So we would be able to report back to this board and let y'all know if it should be an agenda item or not.
Okay. Well,
So
did you have a motion?
what do we need to do? Make a motion to
table that
postpone?
issue? Yeah, postpone that issue.
To request additional information.
Okay.
Yeah.
All right, so I'll make a motion to request additional information and postpone making a decision on this until the next meeting.
Yeah.
We have a motion from Mr. Swindell to request additional information on this item. We have a second by Ms. Thomas. Any other further discussion on this? Seeing none, please vote with your screen.
Motion carries.
Okay. So that would end the discussion on this issue. Is that correct?
For today's meeting, yes.
For today's meeting?
The issue regarding the code enforcement proceedings has been postponed to the October meeting, but the issues before the board today have been
Okay.
addressed.
The BOA case 3430, the one on the apartment complex, that ends the discussion on that. Thank you for coming. Please exit quietly by the rear of the meeting. Okay, the second case.
Yeah, you want to take a 5-minute recess?
Nope. I'm gonna go.
Somebody had to make the motion.
Okay. We got,
Hey, I think you did a great job of reading that stuff, and then particularly when you went to the
A lot of times, I have to read, like they won't believe what I say, but if I read
yeah,
it, there's a little bit of weight behind it. Yeah.
I'm trying to get the cop to get him out of here. Please exit. Everyone, please exit the room.
Unless you have more.
Can I ask them to get their sorry ass out of here real quick?
Sure.
All right. 21 seconds. We're going to roll. The next case on the agenda this afternoon is BOA case 3474. It's a request by an applicant in a planned unit development overlay for a variance to reduce the rear yard setback from 50 feet to 35.1 feet. The property is located at 609 Northwoods Drive, Abita Springs, Ward 6, District 6. The applicant is Stephen and Sherry Barton, and the representative is Jeff Shane with Jones Fusel. Staff comments, please.
While the dimensions of the lots are slightly less than the average of the lots within Block D, the final plat took individual parcel size into consideration when assigning the required setbacks. As such, there's no evidence of hardship or practical difficulties that have been demonstrated to warrant the support of the requested variance.
Thank you. Please state your name and address and your affiliation with this project.
Good afternoon. Jeff Shane of the Jones Fusel Law Firm, P.O. Box 1810 in Covington. I have the pleasure of representing Mr. and Mrs. Steve Barton, who seek this afternoon a variance from you as to their rear setback. I hope that this case will be much simpler than the prior case. I'll see what I can do to kind of keep it on track. So the Bartons live in Money Hill Plantation, and if you'll take a look at the third page of the staff report, you can see where their home is situated on their lot and what their existing setbacks are. Remember, please, or understand that Money Hill is a PUD, a planned unit development, and so when it got developed, the developer had the ability in the PUD to create setbacks for the lots within the development. And those setbacks, of course, are approved by the Parish Zoning Commission and ultimately by ordinance by the council. But the point is that they're not typical what we might call code setbacks that you would have, say, when you had a piece of property that is zoned A3 or A2 or A4. So I really believe that this setback was sort of created out of sight, out of mind, because it was a large lot. Why do the Bartons come to you today? It's because they've engaged Mr. Mike Martin, who's sitting with me today with DMM Construction. They would like to enlarge their home, and in order to do so, they would extend their home to the rear, which would require an adjustment to the rear setback. So if you'll go to the fourth page of the staff report, you will see that we propose that there be a uniform rear setback, still a very healthy 35.1 feet, but that will allow Mike and the Bartons to do what they'd like to do at their location. Maybe perhaps of equal importance is the last page in your staff report. And that is that although we certainly respectfully request and need a variance from you today as to the rear setback, the Bartons obviously, or I should say also, were required to go to the HOA to see how the HOA felt about changing the rear setback. And you will see that this letter dated July 11 of 2023 advises them that the setback variance has been approved, but it cautions them that they have to come before you today. This could have been accomplished also through an amendment to the plat by the developer and to go before the Planning Commission, but that's quite frankly more cumbersome and arduous. We felt that this route of coming to you seeking a variance would be more expedient and efficient. And so again, I don't think that I am understating the issue, but at the end of the day, we're going to take one end of the rear setback from 64 feet to 35.1 feet and make it uniform. With that having been said, I'm going to sit down knowing that if you have questions, I'll be glad to address them. Otherwise, we appreciate your consideration of this request because the Bartons are excited about the opportunity of continuing on with their project.
Thank you. Is there anyone here in opposition to this request for a relaxation on a rear yard setback? Seeing none, is Ms. Barton here?
No, sir. I'm a representative.
I understand. Can I speak to the contractor?
Yeah.
State your name and address.
Yes, sir. Mike Martin, and I live at 78248 Shallow Creek Lane in Covington.
Can you add comment on what's going on?
Okay, so basically, the homeowner is trying to add on to their home, and because of the inconsistency in the rear setback, which is not consistent either with the other adjoining rear setbacks of other properties behind her, all of them seem to be parallel with the property lines. And the Bartons are inconsistent. For whatever reason, when they set this up, they have it 35 feet on one and 60-something feet on the other end. And so we can't do what we need to do unless that is consistent with the rear property line, which we kind of thought it was very odd that it was like that. We thought it might have been a mistake years ago, but so we're just trying to get it adjusted, that's all.
Why do the Bartons need to expand the house?
Because they have a large family living in the house, and so they're on a two-story house, and they want to have a one-story addition on the house.
Thanks, sir.
That's why. Yes, sir.
Any other questions, anything, comments, anything from the board?
Mr. Chairman,
I recognize Mr. Blash.
I'm sorry, thank you, Mr. Chairman. I'm just looking at this in terms of a uniformity of the setbacks. I'm assuming those setbacks are uniform at 50 feet coming back, correct? Okay. I think that really for me, my own personal opinion of this is that it should maybe remain at 64 foot or maybe just take it back to 50 feet, I guess, and then back to the 35.1, if that makes sense, on the southern portion of the lot. In other words,
Did I hear you say 50 feet rear setback?
On the northern side, yes.
No, that is not the standard.
Okay, it is not 50 foot on the back?
No. It's a
Okay.
PUD, and in this, when this lot was laid out,
I understand.
the PUD made it 60 and 35.
No, I understand, but you're talking about uniformity on the other side of in other words, the back lots from this property.
Many of the lots are 35 feet.
Okay, that's my question. I'd asked earlier and he said it was 50.
This would put it into the norm.
Okay, then I have no issue with this at all then. Yeah.
Anyone else have a question or comment?
Mr. Valentine.
Yes, sir. Yes, ma'am.
I assume since there's nobody here that objects to this, their neighbors are fine with this, and obviously the homeowners agree with it.
Question.
That's why we went to the association first. They vet it with the neighbors to make
Okay.
sure everybody understands, and not everyone felt that it would make it more standardized and certainly be in line with their lifestyle.
I don't have a problem with that either.
Yeah.
Thank you.
I don't see any further questions. Anyone like to make a motion?
I move that we accept this variation and approve.
I have a motion from Ms. Thomas to approve the variance as requested. How about a second?
Second.
I got a second from Mr. Blash and Mr. Swindell. Any other discussion?
Close third.
Vote with your screen.
Motion carries. All in favor?
Thank you.
The next case on the agenda for this afternoon is BOA case 3484. Request by applicant in an HC2 Highway Commercial District for a variance to remove 6 live oak trees within a commercial development. The property is located on the east side of Louisiana Highway 1077, north of Faust Road in Covington, Ward 1, District 1. The applicant is Quickway Food Store, James Ballard. The representative is Kyle Associates, LLC, Mr. Eddie Powell. Staff comments, please.
The subject site is proposed to be developed with a gas station and a convenience store. The Unified Development Code calls for all live oak trees over 6 inches DV8 shall be preserved wherever they may be located on the property. As shown on the attached drawing provided, a total of 6 live oak trees are requested to be removed from the site. While staff is not opposed to the removal of 5 out of the 6 live oak trees requested to be removed, it has been determined that the 36-inch caliper live oak tree identified as number 1293 on the plan should not be removed. This live oak does not preclude reasonable use of the property, and the redesign of the development plan is possible to ensure protection of this tree. In an effort to preserve the tree canopy along a state highway and protect the parish's heritage trees, staff has determined that the 2 large grade A live oaks labeled as trees 1293 and 1295 on the plan should be preserved. Additionally, a driveway permit for the proposed access along Highway 1077 has not been granted from DOTD, and the additional access currently proposed to be located from an unconstructed portion of Oshner Extension has not been granted by the parish. As the location of these driveways could potentially change, staff recommends that if the variance to remove the live oak tree is granted, it should be contingent upon the driveway locations staying the same as they are identified now.
Thank you. Who is presenting this, please state your name and address and your affiliation to this project.
Sure thing. My name is Eddie Powell with Kyle Associates at 638 Village Lane North in Mandeville. I'm the engineer with Kyle Associates for this project. We're also doing the landscape architecture design for this project, which the project is to be located at the corner of the new connector road that's currently under construction and 1077, that southeast corner. And the proposed project is a gas station with a C-store. And we've presented a site plan to the parish that initially did show the need to remove 6 of the 10 live oaks on the property. After taking the staff report comments into consideration, we were in fact able to adjust the site plan to only remove the 5 centrally located live oaks that pretty much fall right in the middle of the site where the building and the gas pumps need to go. So I actually have an updated site plan. I don't know if Aaron, if you want to pass those out, but that does preserve the tree number 1293 in addition to the previous ones that we were preserving. So we've actually reduced the number of live oaks that we're requesting to be removed today to 5 of the 10 instead of 6 of the 10. And we have the inches that are going to need to be mitigated as a result of this removal. The plan is to try to do some mitigation on site, but most likely a majority of it will have to be done off-site through the tree bank or maybe some other location close by. So we're looking for your approval for that. We've done all we can with this site plan to try to adjust it and move it around to try to preserve the trees, but the 5 that we're requesting are pretty well clustered all together and just fall right in the middle of the site. So if there's any specific questions that we can answer, we're here to answer. So
thank you, sir.
Thank you for your time.
Is there anyone here in opposition to this project? Please come forward and state your name, address, and your affiliation.
Hi, my name is Nancy Wagner. I live at 33 Hyacinth Drive in Covington. I live around this area. First, I just want to thank you all for your service. I mean, you don't deserve the abuse you sometimes get, so I just want to say that to y'all.
Well, thank you.
You're welcome. You're welcome, Tom. So on the application form where they requested the variance, one of the ordinances cited of the parish is, does the variance appeal request impose an adverse effect on the adjacent neighbor's property or the surrounding neighborhood? And I want to point out that this area on 1077 is flood prone. And if you remember in May of 2020, at Hannon High School, which is on 1077 right near this proposed site, some of the buses flooded. Nobody could get in or out on 1077. And I'm sure that you all, probably most of you who lived here a long time or most of your life, know the value of live oaks in holding in stormwater runoff. And so I would say that this proposed site plan does adversely affect the neighborhood. And I also want to point out that when Chick-fil-A on Highway 21 asked to take down all the rest of the trees in their buffer, they were told that they would have to redesign their plan for their site, not just to take down all the trees. And I understand that Quickway wants to make a big site here. I mean, originally they went through they went to zoning to ask for the site to be rezoned for Highway Commercial 3. Now, there were some negotiations that took place with Councilman Dean and some changes made to allow more pumps in HC2 so they could proceed with this project in HC2 zoning. Well, maybe that just wasn't the right site for adding in however many extra pumps they want to add. If you go on the other side of I-12, right over the bridge opposite the other side, there is already, I believe it is also a quick way over there, and that seems to be making money just fine with the pumps that they have. So the other point I want to stress is I think this request is premature, because it's one thing to say, well, you're going to have to do exactly the way it is no matter what happens with the connector road. They don't have a tie-in from the parish, and they don't have DOTD tie-ins. So why not wait, see where the connector road actually ends up, even though, you know, that's a big stalled project in its own site, and then look at the site plan. And if you say, you know what, we need to put our pumps right where these trees are, why don't you build something else there? So I want to thank you all for listening to my concerns for the environment. And as you all know, what is it we hear over and over again in St. Tammany Parish? Traffic and drainage. Traffic and drainage. And this area did flood badly, and I would ask that you really consider and perhaps have them go back and look at their site plan again.
Thank you. Thank you, Ms. Redding. Is there a Miss Deborah Abear? Please stand up.
She doesn't want to speak.
I heard her.
Oh.
But you're in opposition?
Yes.
Okay, thank you. Is there anyone else in opposition that would like to speak? Seeing none, I'll open it for questions. Oh,
Eddie Powell.
go ahead.
Thank you. So, understand, you know, trees do absorb a lot of water. We would argue that there's still a lot of trees on this site. If you look along the buffers, we have an extensive amount of trees that we're still keeping. We have gone through probably 10 iterations of this site plan to try to make what would work fit within the footprint, but unfortunately the few live oaks that we're asking to remove just fall right in the center of the site. Those live oaks would pretty much exclude anything from being developed on this piece of property. We are fully aware of drainage. We've been working to get the site designed. We're working a lot of different things at one time. We're working with the BOA to try to get the live oak removal approved. We're working with DOTD to try to get the driveway connection to 1077. We've been meeting with the parish talking about the connection to the connector road as well. So everything's kind of running in parallel, trying to get all these boxes checked so that we have a proper site designed. I would point out that this site plan currently only has 8 pumps that we're proposing as of right now, so we did not increase the number of pumps. We recognize the number of trees, we recognize that we're going to have to mitigate some fill, we recognize that we're going to have to deal with drainage, so we've actually minimized this site as much as we can to still make it a viable development. So we'd appreciate your support for the removal of these 5 trees, and I'm certainly here again to answer any other questions.
Please stay right there. Okay. I'll recognize myself. I'm looking at all the different plots that I've seen, and at this point, these are just lines on the drawing. Why can't you move the stuff over and save all the trees? We seem to have a lot of land out there, a lot of property, and if you slid the buildings over, you could maintain all the trees.
Well, we have to maintain parking. We have to provide for proper circulation through the site for the pumps, safe travel for gas pump trucks, and all the customers that would come here. So in order to be able to, this is the footprint that we've created is about as small as we could physically fit on here and still be a viable gas station, C-store development, which is the proposed use for this piece of property. There's extensive amount of live oaks and a cypress tree to the south, so we can't move that way. Like I said, the grouping of the 5 that we're asking to remove, just unfortunately, we're all grouped together right in the middle. So there's just really, we've juggled it. We tried to wedge it up in the corner we've tried to move it around. There's just no way to avoid all the impacts. There's no way to avoid impacts to all live oaks. We're going to have to remove some.
Thank you.
Thank you.
I'd like to recognize Mr. Swindell.
Before we have to do rebuttal from Ms. Wagner, if she has any.
Oh, okay. Thank you.
Thank you, Emily. On Highway 21 at Hyacinth Drive, there's a Chase Bank strip mall. It was one of the early areas built along Highway 21 near the I-12. And the plans there were to cut down the live oaks trees that are in the centerpiece of that development. And I didn't live here at the time, but I understand that there was a huge outcry from the neighborhood, and they redesigned that site to save those trees. So I just ask for your consideration. And I understand they've gone over and over and over and over again, and they need all this other, but the paving and the parking and all of that is more concrete, and then you've done away with the rest of the trees. Those 5 trees I'm referring to. Thank you.
Thank you. Okay. Now, we recognize Mr. Swindell. Your question, sir.
No, I don't have a question. I just wanted to make a comment. Mr. Powell, thanks for actually taking the staff comments in a question and coming with a redesign rather than us having to ask you a bunch of questions and coming back again for that. And then to Ms. Wagner, I appreciate the research you've done regarding precedent that we may or may not have set in the past. You know, it's refreshing to see that somebody's actually done some work to get ahead of that. And I certainly appreciate the flood concern you have. I am not a professional engineer, and I personally rely on our code and ordinances to protect us in that fashion. And it's hard for me to make just a judgment on opinion because I think you know it may or may not result in more flooding. I'll leave that to the professional engineers. I do have a question for staff. When we make a proposal to somebody's going to make a motion to approve this. The trees that they're cutting down, the offset, does that motion have to include a provision that they, pay into the tree bank or whatever, or is that that's going to be required regardless of what the motion says?
Well, it can be part of your motion, definitely, because there's going to be, as stated, replanting on a site, and also, payment into the tree bank. That's what is requested. If I'm not mistaken, I heard elsewhere. Not this elsewhere would definitely have to be defined clearly. But you can add a stipulation.
Okay. I'm good.
Mr. Blash.
Okay, yeah, I just curious because I don't have the answer to this, but I'm looking at, let's see, 1302 is the one we've deemed 1302. That's a 52-inch live oak. How old is that tree? Anyone have an estimate of that? Or 1301, 48 inches. Do we have an idea how old that tree is?
We did not visit the site. I know that our landscape architect did. She might have an idea.
Yeah, I guess my only concern for this is, these seem to be older trees. And at all costs, I know I value live oak trees. Not to the point where I think that, we put them before people, but if there's a way to work through this, and I'm just wondering, and I'm just thinking out loud just to maybe think of something else. I know you say you've been through this you've tried it every way you can. I'm looking at 2 trees that are 36-inch trees versus 52, 48, 24, and even another that is, I can't make it out. I think that's 52 inches too, or close to it. I can't make it out. But those are good-sized trees in that clump right here. The 2 trees I'm talking about look like to be to the west, 1293 and 1295. Those trees. Has any consideration been given to shifting everything that way? And I know there's a buildable area and you have setbacks that you have to concern yourself for safety and everything else. But is that something that's been looked at?
Those 2 are the ones that staff explicitly wanted to preserve, so they would preserve the frontage along 1077 as opposed to the few that are in the center of the site.
Right.
I believe if we were to try to shift everything forward and maintain that same basic site footprint, we would still be impacting 1301 and 1302. All this has to kind of move together. The flow
Right.
of a C-store to a gas pump has certain sort of minimum dimensions to maintain that flow for both, easy access, but also safety for the pedestrians walking from the gas pumps to the C-store. We can't have the gas pumps on one side, the C-store on the other. So to try to, so we have to kind of shift everything holistically. So if we shifted everything to the front, impacting those two trees, I still believe we'd be impacting the other two trees, so then we'd be looking at even more trees to remove. So I honestly believe we've gone through the exercise literally several times to try to find the best fit for the least impact, and this is where it's landed, in accordance with even some of the recommendations from staff.
Yeah, again, just the way I feel about it, it's like, boy, it's gonna take a long time to get those trees back.
No, I understand.
And you follow
Yeah.
what I'm saying? So if there's any way to do it, really
Yeah,
would love to have an opportunity to look at. I was on Carrollton Avenue the other day, and I noticed all those trees that seem to be in really good shape. And there are cars that pass over them every day, and there are trolley cars that pass over them, and there are trucks and everything else. To me, the only point I'm trying to make is, I don't know if it were possible, and this is just my own opinion, 2 versus 5, take out 2 to save 5 seems equitable, but that's just my own opinion.
Okay.
I understand.
Ms. Thomas?
I guess my question is probably more to the staff, but it does say that the driveway permit has not been granted and that the portion of Oxford extension has not been granted by the parish. So when those, if they are approved or whatever, would that not change, could that not change the direction that we vote today? I mean, I'm just wondering what the staff's opinion is on that. I mean, would they have to come back and ask again for some other variance because the parish or whoever doesn't grant the right driveway or whatever?
Yes, ma'am, that's possible. If DOTD were to say that that driveway is not in a sufficient place and request that it be moved, or...
Erin, it's difficult to hear you, I'm sorry.
Oh, I'm sorry, or if Oshner Extension layout would suggest that that driveway move, then it's potential that the site layout be changed, and we're talking about different trees to be removed.
So it does seem to me that perhaps we're jumping ahead until we get until the parish says, yep, we're gonna grant this and we're gonna tell you where it is, and then we have a clearer view because we've got all of the information. I'm a little concerned that we don't have all the information. Just wondering.
I mean, I would argue it could go the other way too. If we don't have approval for the trees, then I can't get site plan approval from the planning department.
Okay, is that correct?
So, I mean, it kind of goes both ways. That's kind of why we're running everything in parallel.
Gotcha.
We intend to do a traffic study. We're waiting on DOTD to provide us with the scope of the traffic study. And the intention of the study is to show that our proposed right-in, right-out only driveway will be constructed in the general location as we show here.
Okay.
As there really is no other good place to put it on the site. So that would be part of the approval process with DOTD, is to get their buy-in on this location.
Thank you.
Any other questions, comments?
I have a comment about the age of the tree and the diameter.
Ma'am,
Yeah,
why don't you come forward and,
yeah, I just Googled it. My name is Joyce Lynn Lowe. I'm a resident of St. Tammany Parish for 30-something years, and I love trees. Built my house around the trees. And according to
how about stating your address, please?
150 Glendale Heights. How old is a 3-foot diameter oak tree? This is because oaks generally take between 60 and 80 years to reach a 3-foot diameter.
Thank you.
Ma'am, can you spell your last name, please?
L-O-W-E?
L-O-W-E?
Yeah.
Okay. Any other comments, questions? Seeing none?
I just want to say I'm the general contractor. I'm here with Eddie. And
Step up to the podium there. Tell me your name and address.
My name is Hunt Ragusa. My address is 638 West Railroad Avenue, Independence. I'm a general contractor that has worked with Quick Way Food Store on all their new C-stores. The owner has made an extreme effort to preserve the live oaks here. In fact, directed us particularly to preserve as many as that we feasibly could. There was a consideration to try to attempt to remove some additional ones, and they really felt like that they wanted to keep those. I wanted to talk about a few things that the ordinance requires. It specifically states that live oak trees shall be permitted to be removed if the live oak tree denies or precludes reasonable use of the parcel property. In this instance, not only do we have buildings and paving that are essential to this development, we also have ponds, drainages. This is a zero net fill site, which is a special, it's a special circumstance for this site. It specifically says that any special circumstances should be brought to the attention. In fact, it's requiring a letter, and this is within the land clearing application. So ponds for drainage and fill mitigation are necessities for building this site, not only buildings and pavings, which those may not show up exactly here, but we need these spaces to be able to design and provide for these special circumstances. One of the ladies making the comment earlier had mentioned drainage. As everyone here probably knows, the drainage requirements are set by the parish, and that's what Mr. Eddy is hired to do, is meet all of the drainage requirements, no matter what trees, no matter what paving, no matter what improvements we do at this site. And that's one of the things that limits us in this development, and we have arrived at the site plan that we've had, is we do not have the space to make this any larger because we don't have space for drainage, different things like that. The requirement also says the live oak tree, it shall be permitted to remove it if the live oak tree prevents access to proposed structure or access to necessary part of building site. These areas that we need for ponds and stuff are necessary parts of building site. The other thing I want to say is Mr. Ballard actually owned the piece of property that the connector road was being put on. He has been committed to helping develop these areas and is really committed to making a nice project here. So the last thing I'd like to comment on your request. In order to remove the live oaks, they either have to be mitigated or replanted. So I don't know if that was clear. That is actually part of the ordinance. Now, where that has to be done is something that can be decided based on the availability of land that we have to be able to plant or pay into a mitigation bank. So, but anyway, I just wanted to kind of better explain a few of those things.
Okay, thank you, sir.
Okay, you're welcome.
Any other questions, comments? Seeing none, would someone like to make a motion, or how would you like to proceed?
I'll make a motion. I'll make a motion to approve the variance as requested with the stipulation that they satisfy the mitigation as dictated by them.
And when you say as requested, that's in relationship to the revised removal of 5 oak trees.
Yes. Yeah, in the layout drawing that he submitted tonight.
I'll second.
I have a motion by Mr. Swindell to approve the variance and subject to the mitigation of the trees or payment into the tree bank. And I have a second by Ms. Thomas. Any other discussion from the board?
This is a tough one. It really is.
It's a tough one for me.
Mm-hmm.
Seeing none, please vote with your screen.
Motion failed.
What's that? Oh.
Motion failed.
What's it pass then? Okay.
Sorry.
The next,
The motion failed. It required 4 votes to pass.
the next, am I on? The next case for this afternoon is BOA case number 3485. It's a request by an applicant in an A2 suburban district for a variance to reduce the front yard setback from 50 feet to 25 feet. The property is located on the east side of Kokomo Lane, Bush, Louisiana, being lots 7I and 7H, Bushwood Estates, Ward 5, District 6. The applicant is Secret Cove LLC, Deborah Hogan. The representative is Paul Marone with Jones Fusel. Staff comments, please.
As shown on the re-subdivision plat provided, the Pearl River Canal runs through the subject properties, making the buildable depth of the lot much less than the originally platted property. A reduction of the required front setback would allow reasonable development of the property.
Please state your name and address, sir.
Thank you, Mr. Chairman, members of the board. Paul Marone, P.O. Box 1810, Covington, Louisiana, 70434. Paul Marone, again, on behalf of Ms. Hogan and Secret Cove LLC. The two lots that are subject to this request are in Bushwood Estates, lots 7I and H. If you're not familiar with Bushwood, it's a relatively low-density residential development in the northeast corner of the parish along the Pearl River Navigational Canal. It's about 20 lots on about 100 acres, with all of the lots backing up to the Pearl River Navigational Canal. As Ms. Lambert noted, our request is to reduce the front setback on these two lots from 50 feet to 25 feet. And as she noted, the hardship is created by the fact that the majority of these lots actually falls within the canal itself. So if you look at the aerial or even the survey, you will see that the actual rear lot line goes well back into the canal, which leaves a buildable area much smaller than we otherwise would be dealing with on a lot of this type. 2 points also I would bring to your attention. One, there have been similar requests in the past. Lots 13, 14, and 15 were similar in that they had the canal encroaching into them, and there was a variance on the front setback that was granted by the board, which would mean if the board were so inclined to grant our request, it would not be uncommon or dissimilar to what is already out there. Also, it's important to note, oftentimes when we're asking to move the structure closer to the roadway, it begs the question, well, what does the streetscape look like? What's on the other side of the roadway? This is a very unique site. As I said, it's low density. These lots are all between Kokomo Lane and the canal. Across Kokomo Lane is the remainder of the development, which is just vacant. It's land that is owned by the developer of Bushwood, but there are no homes there. There's not anybody on the other side that we'll be getting closer to, or we'll have a view of our house that would be something that they weren't anticipating when they built in this area. So it's nothing but vacant green space, if you will, all on the opposite side of Kokomo Lane from these lots. With that said, we would respectfully request your approval for the hardships and the reasons given. I'd be happy to answer any questions that any of the board members might have at the appropriate time. Thank you.
I'll recognize myself. Is there a homeowners association neighbor?
There's a homeowners association, and maybe 8 residents out there, something like that. I may be off a few. It's
did they review this?
Yes, the homeowners association is aware of it.
Okay.
And Ms. Hogan is still, as the developer, is still the party that runs that homeowners association. So I wanted to be clear about that.
Right.
And to my knowledge, I'm not aware of any objection. I know that the property was posted, and I'm not aware of any objections coming through the homeowners association to Ms. Hogan or otherwise.
Okay. Thank you. Yes. Anyone else have any questions or comments on this?
Anyone else here for this case?
Is there anyone else in opposition or anyone else here on this case? Seeing none, would someone like to try a motion?
I'll offer a motion, Mr. Chairman. With regards to BOA case 3485, I'd like to make a motion that we accept the variance request as submitted.
I have a motion from Mr. Blash to approve the variance as submitted. Can I have a second?
I'll second that.
I have a second from Mr. Swindell. Any other comment or discussion? Seeing none, vote with your screen.
Motion carries, all in favor.
Thank you. The next case for this afternoon is BOA case 3491. Request by applicant in an A4 single-family residential district for a variance to reduce the rear yard setback from 10 feet to 6 feet to allow for the construction of an accessory structure and to exceed the total allowable size of all accessory buildings and structures on a lot above 7.5% of the area of the lot on which the main building is situated. The property is located at 1826 Dupard Street in Old Mandeville, Ward 5, District 10. Applicant and representative is James and Marilyn Clark. Staff comments, please.
Can apply for a permit for a foundation for a future accessory building, which was approved and issued in 2021. The applicant later applied for the associated building permit for the construction of an accessory structure in May of 2023. The building permit was denied by the Department of Planning and Development for encroachment of 4 foot into the required 10-foot rear yard setback, as well as exceeding the total allowable size of all accessory buildings and structures on a lot above 7.5% of the area of the lot on which the main building is situated. This request necessitated a variance of 856 square feet.
Thank you. Is someone here for this case? Please state your name and address, please.
My name is Marilyn Clark, and I live at 1826 Dupard Street in Mandeville, Louisiana. Before we get started, I thought that you were going to talk to them about the variance. Ms. Lambert?
That's what we're talking about.
No,
it's a variance on the rear setback.
Yes, yeah, but we did not.
We did not request a variance on the 7.5% of the property.
That was a mistake.
They put that in there on their own. Ms. Lambert was aware of that it's the structure that's already there. They counted the second floor and the first floor, 1,800 square feet. And they didn't count just the base of the building, which is only 800 square feet. We don't need a variance for the.
This is correct. So what's in front of you here is, the first part, the setback variance. However, we don't need to address the 7.5%. It's been corrected.
Okay. Is the board clear on this comment? So all we're talking about is the footage, the setback on the rear setback, the difference there.
That is correct. All right.
That's my understanding. Thank you.
All right, so now that we've gotten that clear, we'll go on to the meat of the subject, okay? We had requested and applied for a building foundation permit, and we were approved, and that number was 2021-60424. And at the time, I think in your package, you will see that at the time we gave a plot, and all of you should have this. And in red it says the building, and it said proposed 18 by 20 building when we applied for the original permitting that we were approved for. And when we even had someone come out and look at the foundation, and we were approved with J hooks being in the foundation, so you knew a building was going there, because we told them when we requested the permit, and then when they came out, when you had your inspector come out, he saw it, he understood that a building was going there, and approved that. When we went back to get the building permit, because it was a separate situation, they then said, no, you cannot put a building on that. And it made no sense, because at that time, I had already put $5,000 into it. So my request from you, please, would be to go ahead and allow me to put that building on the foundation that was originally agreed and approved.
Thank you.
Thank you.
Is there anyone, please step back.
Okay.
Is there anyone here in opposition to this request?
I'm not necessarily in opposition, I'm just.
Please step forward and tell me your name and address, please.
Dom Esquinance, 285 Laura Drive North, Mandeville, but I own the property at 1332 The Mark, which is on the east side of this property. And I read the case and the part about the 7.5%. And I'm just questioning A4, residential zoning. How many buildings does that allow you to build on your property?
Well, I don't think
That doesn't come before you, so I understand that.
we're not addressing the 7.5% today, sir.
Okay, well, I don't have a,
I'm sorry, we're just discussing the accessory building where the slab is already poured,
Okay.
and we're trying to figure that out.
so the parish has already issued a building permit for the property with the allowance of the setback, if you allow the setback? Did I understand that correct? Have you got a building permit yet? Oh, okay.
Okay,
Okay, thanks.
thank you. Anyone else in opposition? Seeing none, I'll recognize Mr. Blosh.
Thank you, Mr. Chairman. I'm very confused because I seem to remember this, but it's a little bit foggy now. It's been a couple of years ago. We approved a variance request previous to this for this exact same slab?
I don't know. I can't remember.
There was a variance granted for another accessory building
an-
on the property.
Another one.
No,
Okay,
it
was
was the
that
same
built?
property.
Another one on this property.
That was built? Okay.
May I? Yes, there was, and this is, I think everybody is getting a little confused about the 7 point whatever, because we're just talking about a small, and it's a very small, wood shop workroom. It's a glorified one-car garage, okay? That's all I'm asking for right there.
Okay.
And I'm putting it there because the last time we came, and the variance was because I wasn't going to cut down 2 giant trees, which are still there, and I'm still having arborists go there. And so I don't want to touch those trees, and that's why we asked if we could put the original foundation back, and we were approved. Now that it's time to put the actual structure up there, I'm being told no. And it makes no sense. Why did you tell me I could put the foundation there?
Well, it's in the setback.
Yeah, but you approved the foundation.
Approved building foundation.
I understand.
For the building,
I understand.
where the setback.
Not for,
Okay.
we didn't approve this. This body did not approve it. That's
No,
what I'm trying
no,
to.
you're talking about another time.
Okay, that's,
Yeah,
okay.
you were right, good memory, but.
Okay.
Okay, please step back. Mr. Swindell.
I mean, this question is either for Aaron or Helen. Is it, so they didn't submit a building permit, but they submitted a permit for a slab. Did the slab not require the same setbacks as a building? Is that why that was granted without coming to us?
Yes, I guess it's a flat surface. It doesn't have the same impact as a building.
Okay. I mean, so there's no error on the part of a parish, somebody in the parish having granted the permit for the concrete? Because it wasn't clear when that permit was submitted, although anchor bolts, to some of us that means a lot, but to some people, J-hooks and anchor bolts don't mean anything. Without it being clearly a building permit, it's possible that I could get a permit to build that close to the property line.
Okay, we did, when we went to get the foundation, we plotted out in red that there was a building going there.
This was part of the permit. See, it's in red, proposed building. This was actually filed with the parish.
I see that. Look.
I guess I'm
Wait.
confused. If you knew a building was going there, why did you go ahead and give me the foundation permit?
And the foundation was a building foundation, had all the rebar, had the wire in it, it had the layout for the foundation, which was approved.
Look, I understand your issue. What you've asked, though, is for people in the parish to make assumptions based on penciled, on remarks on a drawing that a permit was specifically issued for concrete. And I struggle with that because who's to say that later on you didn't pencil that to the other side of the slab or something? I'm just trying to put myself in the shoes of that.
It's in your record.
I know, but
Wait a minute.
we're in a tough spot up here. I'm trying to put myself in the shoes of somebody who was saying yes or no to that permit. And at the time, if I can pour concrete there, I'm going to allow it.
Okay, but it's
You know?
not concrete like you would think. It's
Building foundation.
It's-
This is
it's-
part of the packet that was
it-
given
it-
to the parish.
Jim, you can tell that it's not a driveway or anything else. It is high. So,
I don't disagree with
but I mean, I'm
your
not
struggle with that. I don't disagree with that.
and that's the biggest problem. If I was told in the beginning that you can't put a building there, even though we gave everything to the parish, then why would I have asked somebody to come out there, pour this concrete foundation, and then have your people come there for inspection and approve it? And yes, J-hooks do mean something. I mean, I don't know anybody else that puts J-hooks in something. And it doesn't seem fair as a citizen for me to eat $5,000 because.
Look,
Thank you.
let me just say one more
Yes,
thing
sir.
relative to that.
Yes, sir, Mr. Wendell.
Foundation plan.
Wait a minute.
I understand.
Wait a minute, sir.
Slab,
Please step back.
foundation plan.
I understand. Look, if you dug through our minutes over the last 18 months or 2 years, whatever, since I've been on the board, we've encountered this a couple of times where individuals have done things and then come to find out that what they want to do going forward does not meet the setbacks. And oftentimes it comes with some unfortunate financial difficulty for them relative to money that they've already put into it. It's not fair for us to consider that. As a group up here, we are charged with just protecting the Unified Development Code and those things, okay? So I recognize that that's tough for you, and I understand the bit about that you intended to put a building on this slab, but that's not what that person at the parish who said yes to that permit was tasked. They can't make that assumption, right? I'm just saying, so.
Allow the board member to finish.
I'm just trying to explain my position, that I find this tough. I would like to know more about the trees, though. You mentioned trees is why you want to keep this close to the setbacks. I think that's really an important thing to stress. But I don't have any reference for those trees, the sizes, or what you would be cutting down if you had to move this building to meet the setbacks as required.
Well, the two trees are old growth trees. I did have an arborist come out. They're over 75 years old, and they're huge. And I don't want to cut them down. And I don't want to have to demolish a slab only to pour another slab. I've been so intent about these trees that I've had people hand trench utility lines, water lines, and it's cost me a small fortune to save these trees. So I would like for you, I pray to you, I beg to you, just to reconsider this, because this is, to me, this is a miscarriage of everything that we thought we were doing right. We thought we were doing everything by the code right, and then for you to say to me, and I understand, well, it wasn't their job to do it at the parish. Well, whose job is it when I go there? When somebody looks at the plan, who am I supposed to go to if it's not the parish planning and permitting?
Okay, thank you. All right, recognize Ms. Thomas.
We do have a responsibility to enforce the codes, but the reason we have variances is so that we can make sure that the person that is requesting it has done everything that they can do. So this is a very tricky one. Very clearly what you proposed does in fact have, going back, showing that there was going to be a building there, and we have in the past had this situation and we have granted variances. The fact that you've really tried to keep our trees makes me very happy. And that's really important to me too, and no fault with the parish, no fault with anybody. This is just an unfortunate situation. So I'm very torn by this, but I also know that's why you ask variances.
Understood. Thank you.
Thank you.
I recognize myself. Ms. Clark, what about, is there a homeowners association? Is there, what about other neighbors? Anyone?
We have had neighbors come because the posting of this particular meeting, and they are well aware of what's going on, and none of the neighbors right across the street and right down the street, none of the neighbors that look into my property, nobody has complained. The neighbor directly behind me, no complaint.
But you don't have anything in writing or nothing from that? Is there a
No.
homeowners association?
As far as I know, there's no homeowners association.
Okay, thank you. Mr. Blash.
Okay, like I said, kind of going back, thinking about what we had talked about in the past with regards to another structure which we did approve, and I don't remember there being any complaints or any problems with it. I think one of the things we have to look at is commissioners, is what is the total impact going to be? Now, I can certainly understand where Mr. Swindell is coming from. Where do you stop it? Where do you let it? Where do you end it? You've got to protect your other property owners' rights as well. As I'm recalling, bits and pieces are kind of coming back to me now. There was another property, I think next door, is this similar circumstance without buildings? I can't really tell from the drawings. I think that was part of the argument we had before, that this was not uncommon in that area to have those type of structures close to the property line. They had changed. In other words, the setback had changed from what it was previous. I think maybe 3 feet for accessory, went to 10.
It used to be 5.
Okay, yeah, so that's, so.
I made it 6 feet to fall in line with the 5 feet.
It's a very old neighborhood.
Right.
And so things were done probably 20, 30 years ago that you may or may not approve today, but they're there now and they've been grandfathered in.
Right, and that's, like I said, this is all starting to come back to me now, Mr. Valentine, as I remember. And so I don't think that, in my own opinion, personally, I don't think there's going to be impact on the, or negative impact on the neighborhood or the surrounding properties. The gentleman that had his opportunity to walk up, he didn't have an issue with the actual structure, going into the setback. He was more concerned about the volume of the size of the buildings.
The number of existing accessory buildings.
So, quite frankly, without saying how I'm going to vote, I'm leaning towards this doesn't present a problem.
And I believe we've set a precedent.
Yeah.
For this, in this area. And
Okay.
I remember that particular case, Mr. Blash.
Would someone like to make a motion?
I'll make the motion. In case BOA 3491, I ask that my motion would be to approve the variance as it has been submitted, and striking the 7.6% requirement that had been previously there.
We have a motion from Mr. Blash to approve the variance as requested for the setback. Do I have a second?
I'll second.
And we have a second from Ms. Thomas. Any further discussion? Seeing none, vote with your screen.
Motion carries.
The next case.
Thank you, everyone.
Yes, ma'am. The next case for this afternoon is BOA case number 3492. Request by an applicant in an A1A suburban district for a waiver of the required 25-foot no-cut street buffer along 16th Street for 153 feet. A waiver of the required 50-foot no-cut buffer on the south side for 153 feet. A reduction of the required 50-foot no-cut buffer to 25 feet for approximately 207 feet. The property is located at 61270 Fish Hatchery Road, Lacombe, Louisiana, Ward 7, District 7. The applicant and representative is Mary Mistretta and Avery Ferrara.
Yes.
Staff comments, please.
The subject property is 150 feet in width along Fish Hatchery Road for 360 feet, and it gets wider as the property gets closer to the Bayou Lacombe, imposing a required 25-foot street buffer to the north and a required 50-foot side buffer to the south, allows for a buildable width of 75 feet along the front portion of the site. While staff recognizes the constraint of the property related to the width along Fish Hatchery Road, staff is not in favor of the complete elimination of the street buffer along 16th Street or the 50-foot side yard buffer along the southern portion of the property.
Please state your name and address and your affiliation with this project.
Good afternoon, Avery Ferreira. I currently reside at 1100 Delmar Boulevard, Hammond, Louisiana, and this is my fiance,
Mary Mistretta, and I live at 61480 Fish Hatchery Road in Lacombe, and we are the co-owners of this property.
And as stated before, we are engaged, and this is a home that we are looking to build and move into as our first home together. And to give some more information and background into this property, this is a subdivided lot that we purchased. This is the furthest most right-facing lot facing Fish Hatchery. There were 4 different lots, and I do want to state that this lot only has 150-foot width on the front facing the Fish Hatchery Road. So given that, to our right we have 16th Street, and to our left we have Tract Y. To the right, we will have a 25-foot buffer on 16th Street, and we are requesting that that be moved down to a 15-foot buffer, so for 153 feet into the property from Fish Hatchery, so that we can put our proposed residence there. And we are also asking for the ruling on the left, facing Tract Y, which would be a potential neighbor, of 50 feet buffer. We are asking for that to be moved. We're asking for that to be moved down to 25 as well. I mean 15.
Yes.
My bad, 15.
I don't know if that's the updated plot, but we did modify because we saw that there was a comment from the staff about us doing away with the entire buffer, so we wanted to modify that and have the 215 feet on either side of the house for the 153 feet. And then as the property continues on, we are proposing to have a 25-foot buffer on either side. Now, that one side facing that 16th Street already has the 25, so that one will not be decreasing as you get closer to the waterway. But on the other side, where it's the neighbor, who it's actually my parents that own the property, and so they do not have a problem with this buffer being minimized, we are asking for the 25-foot tree buffer there. Now, I would like to point out that I did read somewhere that properties that are 3 acres or more are supposed to be 200 feet wide, and this one is 150 feet, so adhering to these buffers that are already set in place, it's kind of hard to do because we already lost 50 feet of that width that we were supposed to have. And then besides that, I also saw that the parish put out some commentary where they're trying to increase the property into 5 acres, and then these buffers would apply. So with that in consideration, I'm hoping that y'all will approve us to minimize the buffers somewhat.
Another point, just to add to the rhetoric, the tract is only 2.99 acres, but the current engineer that we have redoing our property survey will not sign off on it as 2.99 and will only sign off on it with his stamp of approval at 3 acres. So that is why we are here today.
Yes, let me see, is there anyone here in opposition to this case? Anybody? Okay. I'm gonna recognize myself. Why, you're gonna put your proposed house way up here?
Yes.
Yes, sir.
Why can't you put it down there?
It's, the
So-
elevation is, it
Yeah.
drops off. I think there's a contour line that you can see. There's a
5 foot.
significant drop
Yeah.
off. I don't even know what type of land it's considered. I don't want to say, oh, it's something else, but it would be, the fill mitigation, it would be And then I think there's ferns and stuff there. We want to keep it to where it's the higher elevation. We're not fooling with anything that could be protected lands. And we really like that landscape particularly. So we just want to cut exactly what we have to cut to fit the house and the driveway, and then keep everything else how we should keep it.
Good answer.
There's also a 100-foot no cut on the bayou for the Louisiana Scenic Bayous. So that would also come into play if we moved the house, if we started to move it more towards the back.
And we're keeping that in place now.
Well, I got the floor. Let me ask my same. Is there a property owners, homeowners association, or?
No, sir.
But you do have, you've got the neighbors because it's your parents.
Yes, sir.
Okay.
And so they're in favor of it?
Yeah.
Yes.
Anybody else? How about other questions? Anybody else? Comments?
So let me ask you a question. Okay, tell me, let me go back to, excuse me, just 1 second. Okay, on the, let's see, I guess on the, is it the west side, northwest side? I'm a little bit confused on this.
North is.
Okay, so that's north, okay. So on the north side, you're asking for a reduction of how much? 25 feet, is that correct, or?
So on the side that's parallel
It's the left side, I
to-
guess, yeah.
Okay, so the one that's next to tract Y, originally that's supposed to be 50. We're asking for that to be 15, just where it's like 153 feet deep. That's basically just along where the house would
Okay.
go. And
Okay.
then it would transition into that 25-foot buffer as you get further into the property.
Okay.
And then on the right side, because that is next to a street, it was going to be 25. We're asking for that to be 15 as well, and then it will transition into the required 25 as it gets further into the property.
Okay. It's an odd shaped piece of property.
Yes, it is.
Mr. Swindell?
Yeah, I'm just trying to get these straight. So are you maintaining any of the no-cut buffer along Fish Hatchery Road?
Yes, the front, the entire buffer will be maintained.
Well, except for where you have the driveway.
Yes, correct.
Yeah,
I'm sorry.
and something on each side of the driveway. Okay, I mean, it looks like the drawing shows that, but it doesn't show the 15 feet along tract Y still. It does look like it shows the 15 feet
They're
along
requesting.
16th.
They're requesting to amend
Yeah,
their original request.
okay.
Just past the contour, what they're saying.
Yeah, I mean, for the record, I appreciate your effort to go back and include some bit of no-cut buffer in each of those locations. And I recognize the lot's an odd shape. So, and you've got to build up between Fish Hatchery Road and that contour line, so.
Anyone else? Seeing none, would someone like to make a motion?
I'll make a motion. I've got to get this straight, though, so, because it's not reflected correctly in the request here as typed. So, with regards to BOA 3492,
You want that to look at?
We have a newer version.
I think I've got it straight. I think I've got it. So, I mean, Helen, I guess what matters is what you have documented. What do you have documented for us to approve relative to what their most current version
So
is?
if you're looking at number 1, instead of a waiver of the required 25-foot buffer, it would be a reduction of the 25-foot no-cut buffer to 15 feet along 16th Street
Right.
for 153 feet. And then instead of a waiver of the required 50-foot no-cut buffer, on the south side, it would be a reduction of the required 50-foot no-cut buffer to 15 feet for 153 feet.
Right.
And then the approval of the reduction of the 50-foot no-cut buffer for 25 feet for approximately 207 feet.
Well stated.
So moved.
All right, so I would like to make a motion to approve BOA 3492 based on the requirements that Helen just stated.
There you go.
I'll second. I'll second what Helen said, and then Mr. Swindell said.
We've got a motion by Mr. Swindell to approve it in accordance with staff comments, and then second by Ms. Thomas. Any other discussion? Seeing none, please vote with your screen.
Motion carries. All in favor?
The next case for this afternoon is BOA case number 3502, a request by an applicant in A2 Suburban District to allow for the construction of an accessory building in the front yard. The property is located at 730 Copal Street in Mandeville, Louisiana, Ward 4, District 4. The applicant and representative is Mr. Salem K. David, Jr., who's been waiting patiently back here. Staff comments, and somebody explain the difference between front yard and backyard.
The subject property is currently developed with a single-family residence, which has been in existence since at least before 1998. Although the property was constructed to face the lake, the residence is accessed from the northerly Copal Street and therefore was assigned a Copal Street address. This address assignment established the property's front yard, which is along Copal Street, and its rear yard, which is along Lake Pontchartrain. As such, the owner is requesting a variance to the aforementioned accessory building standard to place a 40 foot by 24 foot accessory building in the property's front yard.
Thank you. You're welcome. Yes, sir. Please state your name and address and your affiliation with this, and how old is that house?
It's sometime in the 1800s, reportedly.
Sometime in the 1800s?
Basically, yeah. The original house, they've added on to it and done some different things.
Okay,
I bought it a few years back.
I'll
Anyway, I'm
shut up.
Salem
Go ahead.
David, own the home at 730 Couple with my wife. I appreciate you all doing your job. Like the lady said earlier, I couldn't have done this. Sitting here was hard enough, much less watching y'all put up with the mess. Anyway, Ms. Lambert putting up with me, thank you. Anyway, I bought the house. It was built back in the 1800s. It originally faced the lake. There was a street along the lake when they built the home. It was either Lake Avenue or Front Street. That's no longer there. I 100% understand why nobody would want anybody to build anything in their front yard. However, this is not really a front yard, okay? As Mr. Ballantyne drove by there Sunday, it's 0.2 miles long. You're not going to be able to see this accessory structure from Copal Street. Everybody's that borders me, their backyards border my front yard, quote unquote, my backyard, in my opinion, but you know how that goes. But basically, and so everybody there, I've talked to everybody in the neighborhood, not in the neighborhood, excuse me, that bordered my property. Everybody was in favor of it. They liked the idea of me building a storage facility. As you saw, the stuff in my yard looks wonderful. It needs to be covered up, the lawnmowers, the backhoes, not backhoes, excuse me, the bush hogs, all that mess. So I need good, safe, attractive storage. Can't build it between my house and the lake. One, there's not enough property. Two, that would be ridiculous. I did talk to everybody there. I've got letters from the three of them. I think they mailed them to you all. And everybody was in favor of it. I think everybody's going to be better off once it's done. And so, I just think it's something that I can't build it anyplace else. I can't store this stuff under the house. It's not safe. I mean, do y'all have any questions for me? I can't.
Thank you, sir. Is there anyone here in opposition to this case? Seeing none, I'll open it up to the board for questions. And I recognize myself, except I forgot my question.
Was it, which way is up?
I think you've already answered it. My question was homeowners association, but and all the neighbors.
There's no homeowners association.
Yeah, right.
It's unincorporated St. Tammany. However, there is a homeowners group. I don't know if they call those. And actually, one of the ladies wrote the letter is one of the most involved person.
Yeah.
And she's 100% in favor of me doing this because she's looking at some mess in my yard right now.
Good. Okay, any other questions for Mr. David? Seeing none, I'd like to make a motion. I'd like to make a motion to approve the request for the accessory building in the backyard, the variance as requested.
Front yard.
What's that?
The front yard.
They ca- That's the problem. They call my backyard the front yard, but you saw my house, you understand.
I'm sorry. Whatever it is to make it right, that's what the motion. I'm sorry. Mr. Blaze, did you have something else? I didn't mean to jump.
No, not at all. No, I'm just trying to correct you. It's the front yard, remember?
Yeah. Okay. Anyway, I made a motion to approve the request for variance. How about a second?
Second.
Got a second from Mr. Blash. Any other further discussion? Seeing none, vote with your screen.
All in favor, motion carries.
Thank you.
Thank you for your time today.
And I'm getting to
Thank
drive
you for
back.
waiting.
You're gonna be here 4.5 hours?
Now I gotta drive to Tuscaloosa now.
Hey,
All right, well, thank y'all.
me and Mr. Swindell waited till 3 o'clock in the morning one time. Okay, let's try to get this over. Any old business? I don't think I have. Yes, where do we stand with Mr. Spees? So we need to replace Mr. Spees on the board?
Correct.
And,
Someone needs to be appointed.
or vote, I'm getting in front of the parish
The council has the information. They have Mr. Spees's
resignation.
resignation. They do not yet have a new appointee on their agenda, but we will send a reminder email that we do have an open position that needs to be
Well,
filled.
but we got two,
Two alternates.
two alternates, thank you, sir. Two alternates standing in line, do we vote on it, or does
I was gonna ask you if we could make a recommendation to the council,
yeah,
if that's appropriate. I don't even know if that.
Can
let's
we
do
do
it,
that?
let's do it. Mr. Blash it was suggested we make a recommendation to council, what we would like to do, would you like to,
You all can make a recommendation as members of the community. You all cannot, as a board,
Okay.
send that recommendation to the council, but you all are welcome to contact the council members.
Okay.
And
So would that be, we would contact our parish council and make a recommendation as a citizen?
your council person or whichever council person you want, or all 14.
Okay.
who
Or call
appointed,
them all.
Mr. Swindell, who appointed you?
Lorena. But now I'm gonna be I'm changing districts, do the redistricting this year.
Which district will you be?
I don't, whichever one Toledano's running for, I don't know the district numbers.
Number
That's
5.
District
You'll be 5.
Yeah.
So we just do that, okay. So I have no further old business. Is there anything else
I'll send
hanging?
Lorena a request too. I mean, I'll send him a request too, just on my behalf. You know?
Okay, and, you know, my thing is that, so then we need another, alternate, and I'll have to do the same thing. I strongly want to have somebody from, Lacombe. Lacombe, is that right? Yeah, we want somebody from Lacombe.
That is definitely a request you can send to the council persons. The designations for each Board of Adjustment seat are not designated by district or jurisdiction, but if it's definitely a request that you can make of the council.
Okay. If it please the board, I will do that. You know, we keep the geographic diversity going on. Okay, anything else? Old business, new business?
We will have another long agenda. I don't have the exact number of cases, but it will be another long agenda like this one next month.
How about, never mind, I'll shut up.
The date is what?
It is October 10th at
October 10th?
at 2 p.m.
Ooh,
I will not be here.
I will not be here.
I will be going on a little cruise to the Greek Islands.
I will be in Bahaba. I will be in Bahaba, Maine, looking at the leaves.
Why not October 3rd?
Because
Is that
voting.
elections? Oh.
We won't have a quorum.
No, that's what I was gonna say.
So will there be anyone here on the 11th?
No, I'll get back to 13th.
What about the Tuesday the 3rd, which is the first Tuesday?
It's taken by voting. The chamber is occupied by.
Can
Oh.
we change where we meet? Like building C or B?
Well,
I don't know if we
Or
have
is
a
that
room big
not
enough to
ever-
accommodate, not knowing how big of a crowd we may have.
Yeah, I'll be in
It's
town on the
already
3rd.
been
How
advertised.
about October 4th? I mean, could we
We
do
haven't
Wednesday?
No, the whole week.
Oh,
No, we haven't advertised it.
When do you have it advertised, Helen?
It has to be sent to the newspaper. Has to be sent to the newspaper on the 14th to appear on the 20th, the 27th, and the 4th, to take place on the 10th.
And the 10th voting was also, so that week, the 14th is the actual.
Right, but early voting, they do here in chambers, and that's why we can't use the space.
So you will be back, you will not be back till the following week.
I'll be back on Friday the 13th,
Okay.
and I'll be in town until the 6th. I'm gone 6th through 13th.
When would the council be so inclined to appoint another alternate? Is that like this week?
gotta
They
get
have a
on the
meeting this
agenda.
week. It's not on the agenda. They could take it up off the floor, but it's not currently on the agenda to have a new appointee in place.
I'll just go ahead and cancel our trip to Greece. Don't worry. I'm kidding.
Well, no,
Can we move it to the 17th?
if D'Artagnan and Sean show up, we have enough
have a
members.
quorum.
Yeah,
Right.
Okay.
Yeah.
You got 4.
we would have 4.
And there's also a special council meeting too at the end of the month for introduction of the 2024 budget. So I think that meeting is set for September 27th. So it'd be possible that the council could advertise that appointment for that special council meeting on September 27th and have someone seated for October 10th.
Yeah, I think. they
And
should try
another
to do that.
alternate, potentially.
All right,
I think that's what we should try.
that's
to
what we should do.
Yeah.
I agree.
Keep the
That's good
date?
to me.
Keep,
go.
keep the date, or?
October 10th.
Keep October 10th.
Okay.
And
Keep it, and we get contact, talk to D'Artagnan and Sean, make sure both of them are gonna be here.
Yes.
And we got nods from
Yeah, I'll be here.
Brian and Michael, so we're good to go. We got 4, got a quorum. All right, what else? Motion to adjourn.
Motion.
So moved.
Thank y'all.